My name is Ryan Nerney, and I'm joined today by Senior Associate Brittany Forrester. And the subject of today's webinar is what to know about the DOE Department of Energy Security Clearance Adjudicated process. We thought it would be beneficial to go over this today because there are some, I would say, significant differences between what the typical adjudication process is and the Department of Energy's. So as I said, my name is Ryan Nerney. I'm the managing partner at the Ladera Ranch, California office of Tully Rinckey. I primarily practice Fed employment and security clearance law. I've been practicing for almost a decade. I've obviously had a number of cases with the Department of Energy and very familiar with this type of process. So I'll be one of the presenters today, and the other presenter is Brittany Forrester. Brittany, why don't you give us a little bit of information about yourself?
Thank you. Good afternoon. My name is Brittany Forrester. I'm a senior associate with Tully Rinckey. I too primarily practice federal employment law and security clearance law as well. I've been across the country with almost every agency, especially the Department of Energy, to work with the security clearance process from the issuance of a statement of reasons all the way to a hearing. So I look forward to sharing my experiences with you all today. Thank you.
And before we get started on the actual content, I just want to throw out a disclaimer there. So this webinar is not intended to be legal advice. The views expressed in this webinar are ours, Tully Rinckey's, and do not imply an endorsement of the Office or Director of National Intelligence, the intelligence community, Department of Energy, or any other government agency. Now, what we're going to discuss today. So, the overall view of today's webinar is the Department of Energy adjudicative process. So we're going to go through who can have a Department of Energy clearance, the individuals who can do that. What are the designations or levels of a Department of Energy clearance, and kind of how those connect with, the regular DOD or other intelligence agencies levels, if you will. The 13 adjudicative guidelines, essentially the SEAD 4, which is a Security Executive Agent Directive 4, which is a lot of what the other agencies use, and then 10 CFR 710, which is primarily what Department of Energy uses, although they're very, very similar. Some of the language may be a little bit different, but they're very, very similar, and the 13 adjudicative guidelines are across the board, regardless of what regulation you use. The main differences between the Department of Energy and we use the Department of Defense because that's probably the biggest agency who gives security clearances, but there's other government agencies as well, so we'll kind of dabble in that. The appeals process for the Department of Energy, what happens after a decision is made, whether it be from a clearance or from a hearing or a written response. And then what happens after that appeals process is over, the reconsideration or reapplication process. So that's kind of a general overview of the topics that we're going to go over today, and what to expect throughout this webinar. So going first to who can have a Department of Energy clearance. So general rule is that federal employees who work for the Department of Energy or one of the Department of Energy sites throughout the country, there's a number of them. I just put some here: Livermore, DC, their headquarters, New Mexico, New York, Pennsylvania. There's a whole bunch of them. So federal employees who work for the Department of Energy who require, meaning their job descriptions required to obtain and maintain a security clearance, are ones who can have DOE security clearances. Also, employees of companies performing work on a DOE contract. We typically refer to these as contractors, but it's really the company who's the contractor, and these are just employees of the contractor. But that's like Johns Hopkins, Honeywell, other agencies. I know Raytheon, I believe, also works with the Department of Energy. So it's a whole bunch of different ones. It doesn't have to be narrowed to that. But that's kind of, the general overview of the individuals who can get a clearance. But the most important thing for somebody who can have a DOE clearance, and to be honest, this is for any security clearance, is they must have a sponsor by either the Department of Energy or Department of Energy contracting company. Brittany, do you want to go over a little bit about what an actual sponsor is and, how individuals or what essentially how individuals obtain their sponsorship?
Yeah, absolutely. So, for example, if you're searching for a job that is with the Department of Energy, you would most likely locate a vacant position and start the application process by submitting an application for that position. Typically, they will initiate the process and have you initiate the paperwork for filling out the security clearance and going through that process, and that usually requires the SF-86, which is the standard form 86. And so that's the initial steps, is basically finding an employer who has an open position and starting that application process. Once they've brought you on in that initial phase, they are then sponsoring you through the steps in obtaining that security clearance.
Yeah, and to add to that a little bit is also obviously, as I mentioned before, it has to be a position that obviously requires a security clearance. There's other positions within the Department of Energy that don't necessarily require a security clearance. Although, to be honest, the Department of Energy is one of those ones that pretty much every job requires one, just given the location that you'll probably be working at. But there are some that don't necessarily need it. So obviously, it would have to be a position that requires you to obtain and maintain a security clearance. There's also if you have a valid or an active security clearance with another government agency or a contractor, that doesn't necessarily mean you will be approved for a clearance with the Department of Energy, but reciprocity is typically allowed and it's granted. But the Department of Energy does have their own adjudicative process and adjudicative authority. So for instance, DCSA, Defense Counterintelligence and Security Agency, is the organization that typically, or that does adjudicate security clearances for the Department of Defense. That is not the same organization that makes the adjudicative decisions for Department of Energy. Although they have now transitioned into doing some investigations for the Department of Energy, but the actual decision still rests with the Personnel Security Division over there at the Department of Energy. As far as the next steps, Brittany, you mentioned the SF-86. What happens, if you can give everybody some insight as far as what happens after the SF-86 and the potential for potential interrogatories or some additional requests after that.
Yeah, absolutely. So the standard form 86 is approximately 100 plus questions that deep dives into your background, your personal background, your employment background, and what have you. And so it's very detailed, very important that you complete as accurately as possible. After that, that's submitted to the agency. They will typically do a personal subject interview where you'll meet with an investigator. They will deep dive into some of those questions. If they've reviewed the SF-86 and found any potentially derogatory information, or maybe anything that could even be a way of concern, they'll deep dive and ask more questions into those subjects. I've even seen for the higher levels of clearance where they will then interview some of the employers you've mentioned on your past employment section of the SF-86. They've also interviewed personal references to obtain additional information during the investigative interview process as well.
Yeah, and so after the personal subject interview, essentially everything is taken under advisement and there's a decision made on a clearance. If they have some security concerns, they will issue a statement of reasons. For the Department of Energy, it's called a summary of security concerns. It's the same thing, they just have a different name for it, but that's usually what they do. Prior to that, though, they may have some additional questions. Could be some requests for interrogatories. The DOD side is called supplemental information requests, or now more commonly known as it's called the continuous vetting action, which is essentially just asking for additional information. It used to be called supplemental information requests, but there's been a significant transition in names and things like that. The entire security clearance realm is undergoing a new I guess process, if you will, as far as the adjudications and the investigations go, trying to centralize everything a little bit more. But regardless, that's what potentially could happen, and those are the individuals who would be able to hold a security clearance and kind of the process they would need to go through in order to, start that process. Now, the difference here, and maybe Brittany, you can talk a little bit about the difference between the DOE clearance levels versus, other agencies. Obviously, everybody has probably heard a secret or top secret clearance. Department of Energy has a little bit different clearance levels. So, Brittany, maybe you could talk a little bit about that.
Yeah, so primarily the DOE labels, there's a little bit different. There's the Q clearance and the L clearance. And then they also have occasions where they still utilize the secret and top secret clearance that is held by DOD. So the L clearance is what would be equivalent to a secret level. Typically, it's a bit less of a high scrutiny standard to be able to be approved for an L clearance than a Q clearance. Q clearance being at the equivalent as a top secret where you have a significant amount of higher level access, typically is scrutinized at a much higher level than the L clearances.
Yeah, and one of the reasons why they use these different designations, you'll kind of see below, is that they have special access programs, but the Department of Energy is unique in that it has what they call restricted data. So that's a special category of classified information specifically for the Department of Energy, which is typically more sensitive than national security information. So, we say it's the equivalent of a DoD top secret, but, or an L clearance is the equivalent of a DoD secret clearance. But it really comes down to if you have access to that restricted data. So, as an L clearance, as you see here, you can have access to, what they call confidential restricted data, which is a lower level of restricted data. And again, that kind of goes more to like a secret level clearance, secret national security information, things of that nature. As Brittany indicated, the Q clearances are more equivalent to a DoD top secret, but that's also the top secret restricted data. So again, it's more of a other designation that the Department of Energy typically uses for these types of adjudications. So anytime that you hear Q clearances or L clearances, they're meaning the Department of Energy. Other organizations such as like DOD or any of the intelligence agencies don't use that. Also, as you see here, and as Brittany mentioned, you have secret and top secret clearances. Sometimes the Department of Energy does require you to have a secret or top secret through another organization. That's typically if you're working on sometimes they have joint programs with like DOD or something like that, that require, access to classified information on both fronts. So sometimes they'll require you to have that. I know I've had a number of clients who have had both a secret or top secret clearance with Department of Defense, and then also, a Q or an L with the Department of Energy. So, typically the Department of Energy clearance designation is enough, but sometimes, they'll want you to get that designation for DOD or that clearance with DOD as well. So those are kind of the different clearance levels and kind of the difference that you have and that we see. And I know it can be a little confusing sometimes if you have, if you see these types of things, if you've never tried to get a clearance with the Department of Energy before, they say, oh yeah, we need you to get a Q clearance. You're like, well, what is that? I thought it was just secret and top secret. So this is the difference, and that's kind of the reasons why they use these different designations. Regulations for the Department of Energy. So the regulations are very similar. They all stem from the executive orders. I put the executive order 10865 here, which I'll get into in a second. They also have the 13 adjudicative guidelines, as far as what, the adjudication is. The Security Executive Agent Directive, the SEAD 4, they utilize the same mitigating and disqualifying conditions for those 13 adjudicative guidelines that are depicted in the SEAD 4. But for the Department of Energy, the main aspect that they use is 10 CFR 710. These are the regulations that are typically used by the Department of Energy to adjudicate clearances, and it determines the clearance process. So it's very, very similar to the DoD SEAD 4 and incorporates the requirements of Executive Order 10865, 12968. For your reference, the Executive Order 10865, that just lays out what is essentially, I'll call it due process, although it's important to know that security clearance is a privilege, it's not a right. So it's not the same like you would have a property interest in like, employment or something like that. So, nobody has a right to a security clearance. But essentially what that does is it lays out, in order for authorization for access, for some sort of specific category, it can't be finally denied or revoked until the applicant, in this case, the individual who's trying to get a clearance, is given a written statement of the reasons why their access is being denied or revoked. Should be as detailed as possible. A reasonable opportunity to reply in writing, under oath or affirmation of the statement of reasons. Although, like I said before, it's called a summary of security concerns for the Department of Energy. Also, if they have obviously a reasonable opportunity to prepare. If they decide to have a personal appearance, and I'll get into the difference of that in a minute. The opportunity to be represented by counsel. Everybody has that right, regardless if it's Department of Energy or any other organization. An opportunity to cross-examine people either orally or written through interrogatories, and a written notice of the final decision. So Department of Energy follows this. The only difference I would say, and we'll get into this in a second, but the only difference is the ability to have a written response or not. So that would be the only kind of difference to that. But again, everybody has the ability to do that and to essentially respond to a summary of security concerns. We have the 13 adjudicative guidelines on here. Brittany, do you want to go through, just give a brief rundown of what those are, in relation to, the 10 CFR 710, the SEED 4, and then kind of what the common ones you see for the Department of Energy?
Yeah, so you have A through M, just briefly, the highlights of the ones that we see, I think, most frequently involve guideline B, which is foreign influence. You have foreign preference. You have sexual behavior. You have personal conduct. You have financial considerations, use of alcohol, drug and substance misuse. You have criminal conduct. You have psychological considerations, misuse of technology, outside activities. You see quite a bit of the finance, personal conduct, foreign influence. Those are the primary ones. I think a lot come from things that unintentionally get overlooked on the SF-86, typically result in your guideline E, which is your lack of candor. However, it's common that they will also use that as an umbrella, where if you have a criminal conduct, they can incorporate personal conduct, so then you would result in a potential security concern under both guidelines. Same thing if you were to misrepresent a foreign individual that you have close and continuous contact with under guideline B. Those are the typical ones that I've seen. Ryan, do you have any additional on that one?
Yeah, I mean, for Department of Energy, typically what we see a lot of are, financial, drug and alcohol use, personal conduct. Those are the main ones we see. I have actually been seeing financial creep up a little bit more, but for the majority, those are the ones that we typically see. We'll get into kind of how that is a little bit different from like the DOD process, but that's typically what we see for Department of Energy. Not sure why, but those are just the ones that they tend to kind of focus on. But just because the Department of Energy typically focuses on that doesn't mean that none of the 13, all of the 13 adjudicative guidelines aren't fair game. Again, it's all looked at relative to somebody's ability to obtain and maintain a security clearance and to actually hold a security clearance. So they look at the adjudicative guidelines and disqualifying conditions, the disqualifying conditions and the mitigating conditions for each one of those guidelines. So, just because they have some common ones doesn't necessarily mean that they can't tag you for any of the other ones. So like I said, obviously the SEED 4 is the one that's typically used. Those are where the 13 adjudicative guidelines are housed, if you will. And then 10 CFR 710 are the regulations that DOE typically uses. They do reference in the 10 CFR 710 all of those 13 adjudicative guidelines. So that is also, like I said, it incorporates those in there. But those are the typical regulations for the Department of Energy, and that's typically the difference. Typically DOD or other agencies are, the seed for, or if it's like intelligence, it's intelligence community directive, 3 or 4, depending on what you're looking at. But they all come back to the same thing, which is those 13 adjudicative guidelines. The next aspect is probably what I think is I don't want to say most important, but something to really be aware of are the similarities and differences between the Department of Energy and other government agencies. So Brittany mentioned earlier, obviously you have an SF-86. All organizations are now using what they call EAP. They used to use EQUIP. Essentially, it's the same thing. It's just an electronic online SF-86 that you fill out and submit. The EAP, it's a little bit more user-friendly, but in my opinion, it probably takes a little bit longer just because they have so many questions, and they ask questions that aren't necessarily relevant to everybody. But so you have to go through and answer those questions as well. But that's their online process that they're using. Also as Brittany indicated, they have personal subject interviews. Typically Department of Energy was using the security division to do those. Now it's DCSA is creeping in there, and they're actually doing personal subject interviews for the Department of Energy. So they're trying to kind of do this I guess they're bringing everything into kind of one central thing. So there's not a lot of, major differences, if you will. Regulations we already spoke about, but the biggest thing I think that you can take away from this is that on the Department of Defense side, majority of other agencies as well, any of the intelligence agencies, you typically have the ability to do, so once a statement of reasons is issued, you typically have the ability to do a written response first, and if that written response is not enough to mitigate the concerns, you can go to a hearing or a personal appearance, depending on the circumstances. So most agencies have that ability. For the Department of Energy, as it sits now, it's either or. Or excuse me, it's either one. You have to do one or the other. You can't do both. So the adjudicative process is you do a written response. So you get a summary of security concerns issued, and they give you an option. Typically, it's within 20 days. You have to notify the particular point of contact on what you want to do. And then if you elect to have a written response, that goes to the manager of that division, and they make a determination based upon the written response you submit. You do not have the ability to have a hearing after that. Or you can elect to have a hearing in front of an administrative judge with the Office of Hearings and Appeals. It is called OHA for the Department of Energy, for short. But you have the ability to do that. But if you submit, if you do a hearing, you don't typically do a written response. You essentially what it is you just have to notify them. So you give them a notice of, intent to do a hearing. Within that notice, you can do a written response per se, right? So you can potentially do, discuss if you agree or not with the allegations in the summary of security concerns. In fact, in the instructions, it says, you need to admit or deny the allegations. But you're going to have a hearing on it. So it's not going to be a full-blown written response. And again, like I said, if you do the written response by itself, you won't have the option to do a hearing. So typically for Department of Energy, the best course of action is to do a hearing. Obviously, each situation is a case-by-case basis, depending on the circumstances, the facts of the case, and things like that. But typically that is the major difference is that either you can do a written response or a hearing. You can't do both, whereas other agencies, you get the option to do both. Another, we'll call it similarity, or difference, I should say, are expert witnesses. So you can, a lot of times for the Department of Defense, I'll use that as an example, while they have the ability to do expert witnesses, most of the time they do not. The difference with the Department of Energy is that they like to use expert witnesses in almost all of their cases if they can. Typically that's with, specific adjudicative guidelines, but, they do like to use the expert witnesses. So, Brittany, maybe you can go into a little bit more information as far as typically where we see the expert witnesses come in and kind of what their role is within that hearing for the Department of Energy.
Absolutely. So we see them a lot with summaries of security concerns that involve guidelines G, H, and I, and that is the alcohol use guideline, the drug and substance misuse, and psychological conditions. Typically, sometime after they issue the summary of security concerns, they will do a psychological evaluation with the applicant or the respondent to the security clearance concern. And in that, they will develop an evaluation. They will then have the expert witness appear at the hearing if there is one, and they will listen to the applicant's testimony throughout the hearing, and then they will have a turn to speak and be questioned by the government's attorney, and then cross-examined if you were to take an attorney to your hearing, or by the applicant themselves. It is known and common that their opinion and their overall concern as to whether the allegations still remain a concern at the end of the hearing is a heavy weight on the judge's opinion. It's very well noted throughout their decisions that they do take into account and place quite heavy weight on the expert witnesses' opinions on whether or not the applicant has properly addressed the concerns under those particular guidelines and whether or not they remain a security concern.
Yeah, and so to backtrack a little bit, just because they put a heavy weight on an expert witness, I should say a DOE expert witness, and their testimony, doesn't mean that can't be overcome. In fact, I've actually seen it even the other way, where an expert witness from the Department of Energy testified that everything was good to go. And the judge still found, not in the favor of that applicant. Fortunately, we didn't represent him at the hearing, but it happens in that circumstance. But to backtrack a little bit, going a little bit more into the adjudicative process for Department of Energy. So I referenced, obviously, you have a written response. If that's the option that you choose, essentially you submit that written response. The manager of that division looks at everything, makes a determination based upon that written response if they're going to grant the clearance or not. If they don't, then the appeals process, which we'll talk about in a minute, falls into place. If you decide to do a hearing, then typically what leads up to the hearing is a judge, and this is why I think the Department of Energy is good and efficient, is because they have to assign a judge. Once you submit that notice of hearing, that you want to have a hearing, they typically assign a judge. In fact, they have to assign a judge and have a hearing within 60 days. So it's not just, the judge reaches out to you on day 59 and that's it. They typically do, barring some unique circumstances, availability of people, things like that. They will typically have a judge assigned and a hearing within 60 days. And then once you have your hearing, Department of Energy is usually pretty good about getting a decision back within, it's usually about 45 days thereafter that they get that decision. Sometimes, again, it can be a little bit longer. But that's the situation as far as that goes. But what leads up to that is, the judge is assigned to the case. They typically like to set deadlines for, usually it's about a week out for any type of exhibits or documentation that you want to submit at your actual hearing itself. Same thing with opposing counsel. As Brittany referenced earlier, there is a government attorney that is going to be there at the hearing as well. The unique thing with Department of Energy is that although they're technically adversarial, they do also provide some favorable information within their presentation as well, which is not always the case for like Department of Defense or other government agencies. Now, with that being said, they bring in unfavorable information as well, and they typically try to focus on that, but I did find that an important point to bring up. Once that happens and everybody submits their documentation, then another unique thing with the Department of Energy is that the judges typically have a pre-hearing conference. If you've been doing this for as long as I have, or as long as Brittany has, those pre-hearing conferences probably last about 2 minutes. But it typically is the judge's opportunity to kind of go over things, what their process is or what their standards are for, the hearing, kind of how they like to hold the hearing, and can kind of control the environment, go over any objections preemptively for any of those exhibits, discuss any witnesses. And they do this to kind of streamline the hearing a little bit, so you don't have to do all that preliminary stuff at the actual hearing itself. It's already, it's mentioned at the very beginning of the hearing, and that's it. And then once that's done, then you actually have your hearing. And like I said, the judge takes everything under advisement and typically makes a decision within, I would say, about 45 days. I've seen a little bit longer. I've seen a decision come back as quickly as a week. Which is very rare. That's the exception. It's not the rule. But that's typically what I see. And then obviously, as Brittany indicated, they typically like to have expert witnesses, for their hearings themselves. Going to the Department of Energy appeals process. Brittany, do you want to talk about that a little bit?
Absolutely. So once you receive the decision, typically the decision is sent out electronically, and they'll go ahead and send the hearing transcript and the entire record of the hearing, which includes all of the documents that were submitted, your hearing exhibit as the applicant, any of the government's hearing exhibits. And so typically once you receive the decision, you've also received the full packet of everything that was involved for the hearing. With that, you'll have a 30-day time frame to submit an appeal. And in that is essentially a legal argument as to evidence that was not properly weighed or misweighed by the judge, facts that were incorrectly found, pinpoint holes into the argument that the judge makes in regarding how they found and came to their decision. No new evidence can be included in an appeal. It is simply going back through the transcript, the evidence that was presented, and the judge's decision, and again, finding argument to support areas that are weak in the judge's analysis. Case law, there is significant case law that can be persuasive and used in those appeal briefs that we submit. And we pick out cases and we look for similar cases that have been found in the alternative. And in support of that, we submit those as part of the appeal brief in an effort to show the appeal board support based on past cases and past findings of how they should have ruled in this case.
Yeah, and as you see here, in the slide, if you can see, both the applicants and the agency counsels have the ability to appeal the judge's decision. So even if an applicant receives a favorable decision, that agency counsel does have the ability to submit an appeal. It is rare that happens, I'll say. I think I've had only a handful of times that's happened with the Department of Energy. It's usually because the judge just royally screwed up in one way, shape, or form, which is also very rare. It doesn't really happen. These judges are usually very good at what they do and reviewing all the evidence and everything like that and being very thorough with their responses. However, sometimes obviously people make mistakes. So I've only seen a handful of times with that, but that is something to keep in mind. If you do get a favorable decision, typically, like I said, same time frame applies. They have 30 days to respond or submit their appeal. You will, if they do decide to do that, you will have an opportunity to submit what we call a reply brief or a reply to their appeal. So it's not the end of the world. You do have the ability to do that. But both sides can actually submit an appeal. Another thing, Brittany mentioned, obviously, for the appeal itself, it does go to an appeal panel. So there's a three-member panel. Typically it consists of, some sort of Department of Energy headquarters employee. So that's the one like in DC, a DOE attorney, deputy director for, security office, environment, health, safety, whatever. That's another one. And then also the designation by the chair. So essentially the chair, which is typically that DOE headquarters employee, they can pick, another third member that kind of applies to one of those categories to be the third member on the actual appeal panel. So that's kind of the makeup of that. One thing that Brittany mentioned is that there's no new evidence. That was not always the case with the Department of Energy. And to be frank, I was very upset when they changed that process because we used to be able to submit a whole bunch of different evidence, things that maybe not were considered by the administrative judge, some things that were overlooked, what have you, or even after receiving the judge's decision, we used to be able to submit some evidence or documents to kind of address some of those things. That is not the case anymore. I think it's been 2, maybe 3 years since they've changed that, maybe a little bit longer. And now it's more akin to the DOD process, which is no new evidence. Your arguments are basically based upon if the judge screwed up and the reasons why the judge made that error. So that's important because that's something that we aren't able to do anymore, which also makes these appeals more difficult. That doesn't necessarily mean that an appeal is not worth it, for lack of a better term. Sometimes, like I said before, judges make mistakes. Things can happen where maybe a judge overlooked a piece of evidence that maybe he thought wasn't important, but looking at it again, it was extremely important. So pointing things like that out on appeal could potentially result in a favorable adjudication. You see here as well. So I mentioned at the very outset, 10 CFR 710 kind of has the adjudicative authority for, in the process, if you will, for Department of Energy. So the appeals process is a part of that as well, and that's explained in 10 CFR 710.28. It's actually 2.9 as well, but 2.8 is the main aspect of it. And that kind of lays out everything that Brittany and I just kind of went over for the appeals process, for the Department of Energy. What happens if you have your clearance denied or revoked? Can you do anything else after that? Is there any reconsideration? What happens? So again, I'll have Brittany talk about this in a second, but the Department of Energy used to be a little bit different a few years ago. Their reconsideration process used to not require you to wait. Now you have to wait. I'll let Brittany kind of talk about the length of that in a minute, but now you have to wait, unfortunately. But prior to, there was no deadline to wait. You could appeal. That appeal decision came back. The next day you could file for reconsideration. That is not the case anymore, unfortunately. And they did amend the regulations, which, as you see here, are governed by 10 CFR 710.31. So that's not the case anymore. There is a waiting period. So Brittany, why don't you go into a little bit more about what's the waiting period and what kind of goes into the reconsideration or reapplication is sometimes referred to.
Yeah, absolutely. So it is a 1-year waiting period. Essentially, the idea is to allow more time to address the concerns that the government had. For example, drug use. There's no bright line rule within the case law or past decisions as to some of the things that go into an individual who has past drug use and has reported it. However, it is known and has been shown through case law that the longer the time since the last use, the better the case. So again, waiting that 1-year period gives you time to produce additional evidence to show that you have more time since whatever their concern that they've addressed has occurred. And so you would essentially want to go back and readdress and provide evidence to show that their concerns are mitigated at that point. And again, that 1-year period allows you the additional time to do so. Now, being said that, that's 1 year to reapply with the DOE. You can apply at other agencies. However, having to report a revoked or denied clearance on the SF-86 could lead into adjudication process issues with other agencies as well. So that's something to consider.
Yeah, Brittany, that's a good point too. So, just because you're denied at the Department of Energy doesn't mean that you'll be denied at another organization or that you can't get a clearance at another organization. It will probably make it more difficult to do so. But as I mentioned previously, the Department of Energy has their own adjudicative division. Has their own kind of division. So, that's something that is is beneficial if you're trying to get a clearance with another organization. But again, it is something that would need to be reported. You know, on the SF-86, there's a question specifically that asks, you know, have you ever, you know, had an investigation for a clearance? Have you ever been denied a clearance? You know, so any of those questions, typically I think it's within the last 7 years. It may be ever, I can't remember off the top of my head, but you know, that would be something that would have to be disclosed. You know, and that's not necessarily just for an SF-86. It could be what they call an SF-85P as well, which is for typically for public trusts, you know, high-level public trusts that individuals, you know, have to fill out. It is something that would need to be reported, you know, for past investigations. It doesn't necessarily have to be a clearance investigation, but you know, that's kind of what the process is, and kind of what triggers the reconsideration or reapplication. You know, as Brittany indicated, you have to wait 12 months to do that. When you wait this 12 months, you know, essentially you would have to have another sponsor. So you can't just, you know, if you lose your job or something like that because of the first denial, you can't just, you know, submit a reconsideration. You would have to go through that same process, have to get a sponsor. You would have to submit a new SF-86 disclosing all that information. And then typically they give you an opportunity to submit some additional information or evidence to typically is to the division manager. So it would be the same one who would be reviewing it if you decided to do the written response at the original adjudication. But they would be reviewing the reconsideration request. You are allowed to submit new evidence at this point, as Brittany indicated, which is another benefit to this. You know, you can submit, you know, one of the things Brittany mentioned was, you know, new evidence for like a drug case, right? So, and she also referenced the amount of time that's passed. So if, you know, you want to try and show that, you can potentially produce like additional drug tests or something along those lines that kind of show that you've been absent from any type of legal drug use for that period of time. So that's a benefit for that. You know, Brittany, maybe you could talk a little bit about what happens if you do submit this reconsideration request and that's denied.
Yes, unfortunately, if it is denied, I believe it is yet again another year period, and it's the same process again. You know, that would allow you again to, you know, seek out possibly working towards a clearance with a different agency and/or gathering additional information to try again and submit additional evidence again after another year period.
Yeah, and honestly, it's an unending cycle, right? You know, so if you get denied again on the second reconsideration, you have to wait another 12 months, and then you can do it again and again and again. You know, obviously, the more times you do it, probably doesn't look the best if you keep getting denied, you know, on that. But that could just be something as simple as just not taking the appropriate steps to show what that mitigation is. You know, so there's various different ways that you can do that, but yeah, unfortunately, if the reconsideration request is denied, you have to wait that 12 months again before you can do that. So so that's kind of the whole process for Department of Energy. You know, like I said, we kind of went over you know, the similarities and differences for that. You know, and there are some significant differences. I think one of the biggest things, you know, as Brittany and I were discussing earlier today, was that you know, it's the fact of, you know, if you can have a hearing or not. You know, you're essentially waiving your opportunity for a hearing if you decide to go the written response route. So, you know, typically, you know, you, like I said, you kind of have the ability to submit, I guess, a mini response if you request that hearing. So, you know, that typically would be the best route to go. Again, each case is a little bit different, so you have to kind of make that assessment on your own, but that's typically the best way to kind of go along those lines. And again, kind of the same situation with the regulations that they use. They use 10 CFR 710. And you know, the process is a little bit different, although they're getting a little bit closer in line to the Department of Defense. One last thing, I think we missed this. You know, Brittany was referencing the decisions, and we were talking about, you know, once you have a hearing, you know, those decisions and, you know, how long they take. The good thing about the Department of Energy, now all agencies do this, and now DOD does this, but they're not as quick. But the Department of Energy also puts the decisions online. There's an online location where you can go and look at the actual decisions itself. Obviously, all the personal, PII information is all redacted, so they're not going to know the names or anything like that, but you will have a case number that you can check, if that's the case. I know there was a few questions that we had submitted previously. Some of those questions are more case specific, so we're not going to go over the case specific questions, because that's not going to be helpful for everybody. It's going to be more, along the lines of, helpful for that individual. So there's a couple things that we saw here. We talked a little bit about the process of being reinstated once security clearance, has been revoked. The question for that I'm thinking is kind of akin to what we were discussing before as far as the reconsideration process. But on the flip side of that, if you go to a hearing and, sometimes you're placed on indefinite suspension or something like that in the event that your clearance, is suspended or is under adjudication, or you're taken off a project or something like that pending the adjudication of your clearance. Typically, if your clearance is restored, you're usually put back in that position fairly quickly. I've seen it as quick as the next day. Sometimes it takes a little bit longer depending on what project an individual is working on. But if you do get a favorable decision, and there is no appeal from the agency attorney, sometimes that's just waiting the 30 days. Sometimes that is, the agency attorney indicating they're not going to submit any type of appeal. So, but anyways, it's typically fairly quickly after that that you would be able to get reinstated into your position. Looks like we have a couple more here. If it's just a public trust, do you need to report denied clearances in other agencies? Typically, yes. It depends on what form you're filling out. I mentioned before the SF85P typically has a question related to past adjudications, and if you've been denied a clearance. But to be honest, they're going to be able to find out about that anyways. And even though public trust is a public trust, I call it a glorified background check, but it technically is a clearance level. So it is something that you would need to disclose. For no other reason than they would be able to find out that you were denied a clearance previously anyway. So if you're trying to withhold that information, it probably wouldn't look good. Next question is, will the Department of Energy consider someone who is being considered for a clearance with another agency at the same time? Brittany, you want to take that one and see? We kind of touched on that a little bit, but.
Yeah, and I think that they would not have an issue with it as long as you're being sponsored. As we mentioned earlier, it's very common, especially if you're a contractor working for a contracting company that may have multiple projects that are involving different levels of classified materials. So you may have someone, for example, working for Honeywell, which was one of the contractors mentioned in the earlier slide. You may need a DOD clearance and a Q or L level clearance. So you may need to undergo those two different processes at the same time. And while they're similar, they are two different separate processes for the two different adjudications on the clearance. So there shouldn't be an issue in going through both of those at the same time.
Yeah, I referenced as well before at the very beginning, sometimes even depending on the project you're working on, it could even require you to have a clearance with the Department of Defense anyways. But yeah, they usually don't care, to be honest, as long as it's not interfering with what you're doing with the Department of Energy. But most of the time, it's not a big deal, and you can, and in fact, sometimes it's even required to have a clearance with another organization if you're working on a project that requires that. Looks like we got one more here. What does the monitoring process look like for public trust once you have it? They have, the public trust wasn't as I guess I don't want to say important, but it wasn't as scrutinized as like higher level clearances in the past. Public trust is a part of what they call the continuous evaluation program now, which means that they can essentially monitor and pull your public trust or pull your file, I guess, at any time. You also, even with the public trust, you also have reporting requirements for that as well. So if it's something that using a denial, for example. I mean, if it's something that, you were denied a clearance, for something, I mean, if you're filling out an SF-85P, you have to disclose that if that's a question that's directly asking for it. But to go back to the question, the monitoring process for a public trust, once you have it, I mean, they can look at it at any time at this point. How much they want to look into that really kind of depends, I guess, on who's actually looking at your case. If anybody reported anything, to the Department of Energy or even the DOD. So it really kind of depends on that circumstance. But I mean, they're going to monitor it, and they are part of the continuous evaluation program now, which is essentially a continuous monitor. You know, you know, that essentially means is that, they could, if they're tipped off by some sort of, individual who filed, an incident report or, something along those lines, that they would look into that. Or, they could randomly just decide to pull your, credit report or a criminal background check. And if there's something on there that wasn't reported, then that's something that, could potentially lead to some issues. Also, like I mentioned before, there also is the self-report requirement. If it's something that is a potential security concern, there are reporting requirements that have to be followed. And if they're not, then and they find out about it later, then that could lead to not only the issue that should have been self-reported as being a concern, but also personal conduct for failing to disclose that and failing to do that. So, that's kind of the aspect of the monitoring. That is pretty much all we have. Brittany, is there anything else you want to add or you think we should touch on?
I just wanted to add one more thing, especially with the DOE process. In my personal opinion and experience, I think if you have a security concern related, excuse me, to guideline E or any of the alcohol psychological evaluations, I think it's important that you would seek out the hearing. I think it's important that an administrative judge has the opportunity to hear you testify regarding the allegations, to be able to truly judge your veracity, to make judgment on your character, whether or not you're telling the truth. I think a lot of those things go into the decisions that can potentially get overlooked by just submitting a written response. So, I may be biased as an attorney, but in my experience, I do appreciate the hearing process, and I think it's more helpful to have, especially for those candor-related guidelines.
All right, so that'll do it for our webinar today for the DOE adjudication process and what to know about that. Obviously we're doing these webinars all the time, on any subject you want to think about, to be honest. So, keep a lookout for those. But thank you so much for attending. We appreciate it.